There are a variety of federal, state, and local statutes, rules, and codes that require certain public and commercial buildings to be designed in a manner such that they are readily accessible to and usable by persons with disabilities. Such accessibility requirements address things like ensuring that persons in wheelchairs have accessible routes through buildings, and that doors are designed wide enough to allow their passage, that light switches, thermostats, and electrical outlets are located within their reach. The kitchens and bathrooms include features and are laid out in such a way that an individual in a wheelchair can maneuver around and make use of the space. Now, Subchapter 3 of the Americans with Disabilities Act is just one of many places where you will find accessibility requirements, and it prohibits discrimination on the basis of disability in places of public accommodation and services that are operated by private entities, and requires that newly constructed or altered places of public accommodation to comply with the ADA standards for accessible design. Now, these are very worthy standards, I think, for societal reasons and just good practices. It is wonderful that we live in a country that has these sort of standards, but they do present grave risks to owners of property, developers of property, and the design professionals that design them, either at the outset or when they are being altered. And often owners don't understand their obligations under these accessibility requirements, and then they can get hit with claims by a variety of different people. There are claims that can be brought by the Justice Department. Certain organizations have standing to bring claims, and then there are private individuals who have the ability to bring claims, because obviously there's too many buildings out there for public agencies, the Justice Department, to monitor this. So the law empowers essentially private attorneys general to file civil claims in the event that there is a place that does not comply. And in many instances, there is the ability of successful claimants to recover their attorney's fees. So you have this risk of claims. And then when owners get hit with claims, they often turn to designers, and they look for the designer to hold them harmless or indemnify them, which is something that is more murky in this area of law than in most, for sure. But there are two different things that I want to really talk about here today with respect to designing to accessible standards. There are two different things and two different standards. And the first is new construction and alteration projects, which are generally held to a pretty high standard, the readily accessible standard. And the other thing I want to cover is the removal of architectural barriers in existing facilities, which is subject to a standard that requires a little bit more judgment. It's the readily achievable standard, which can be very high, or it can be somewhat lower on the specific circumstances. So let's start first with the simplest concept, which is a little bit easier for owners and design professionals to understand. And before I jump into it, I'll just take a step back and say that while many building codes do incorporate the accessibility standards, they're not building codes. These are laws that are promulgated in some instances by the United States Congress, and then agencies will fill in the specific standards, and then they're subject to a bunch of administrative decisions and differing court opinions. Even within Illinois, not all of the federal district courts agree on what the standards are. So in many respects, these accessibility standards can be, I don't want to say unknowable, but much less readily susceptible to reducing to an arithmetic formula than almost every other aspect of design. So starting with the first concept, which is, while not arithmetic, a little bit more knowable in terms of what owners and designers are able to ascertain that they need to comply with, is new construction and alteration projects. So we're talking about a building that doesn't exist versus a building that does, and the owner has just made a decision that they're going to make some changes to the building. Now, these are subject to the high readily accessible standard. So For newly constructed facilities, design and construction requires that they be made readily accessible and usable by individuals with disabilities. Now, this isn't exactly strict compliance with the standards, but pretty close, right? And it makes sense because if you have a brand new building, you ought to be able to lay it out in such a way that it complies almost entirely with the prevailing accessibility standards, whether they're federal, state, or local. For new projects where an owner has decided that they're going to alter an existing facility, compliance requires that the altered facilities be readily accessible to the maximum extent feasible. So there are some limited exceptions for technical infeasibility. You know, for example, if you have a physical constraint like a load-bearing member that's an essential part of the building that robs you of the space that you need in order to strictly comply, there's some wiggle room when you are making adjustments to an existing facility. But where the standard becomes a little bit less knowable and harder to apply is when we start talking about removal of architectural barriers in existing facilities. And there the standard is whether or not removal is readily achievable. So we're not talking about a new building, and we're not talking about an existing building where the owner has decided to undertake a construction project. We're talking about the obligation generally of building owners to remove architectural barriers to accessibility. And so this is something that whether or not you are planning a design and construction project or not, if you own a building, it's something that you need to be concerned with. Now, the ADA defines readily achievable as easily accomplished or able to be carried out without much difficulty or expense. And the last part is important, expense, okay? And because it is a determination that is made on a case-by-case basis. Whether or not an existing facility it can be brought up to that readily achievable standard is not something that is it's something for an architect or an engineer to study and pass on. Whether it is readily achievable for an owner to remove a particular barrier depends in part upon financial considerations, including its assets and operations. So it's not just an architectural or an engineering issue. And those architects or engineers that get in the business of advising owners about whether the removal of existing barriers in facilities that already exist is readily achievable can subject themselves to unanticipated liability exposures. Generally, a well-advised design professional's role in determining the feasibility of barrier removal should typically be limited to identifying the potential barriers to be removed and suggesting alternative designs. Whether or not it is readily achievable for an owner to remove any particular barrier is generally not something that a design professional is going to want to be that closely involved in, because again, if you are a multinational corporation with lots of assets, you're probably going to have a higher burden to bring yourself up to the existing standards than if you're someone a small business owner that owns like a dry cleaners or something like that, barely scraping by. And so I think that the takeaway here is that owners of property, developers of property, architects and engineers, other design professionals need to get counsel on what their obligations are. It is a mistake for owners and developers to think that they can be fully protected by passing off the obligation under the ADA and similar statutes like the Fair Housing Act, building codes like the Chicago Building Code, to just say that's something for the design professional to worry about, I think is a mistake. So whether you are a real estate developer or a property owner, whether you are an architect or an engineer, when you're talking about what is your obligation with respect to accessible design and construction, it is important to take counsel from a design and construction attorney or a real estate attorney or somebody that has knowledge in this area, because it is unlike virtually any other aspect of design and construction and carries with it tremendous risks of claims.